Good morning, members of the media, colleagues and fellow Canadians. My name is Nicholas Marcus Thompson, and I'm the President and Chief Executive Officer of the Black Class Action Secretariat, the organization that is coordinating the Thompson class action. I speak on behalf of thousands of black workers who've spent years fighting for a fair, equitable, and just public service. We gather here today with two clear messages. First, to announce that we have officially filed an appeal to the Federal Court of Appeal in the Thompson versus Canada class action. And second, to issue a national call to action to all political parties in this federal election. I am joined here by my colleagues, Hugh Scher, who is plaintiffs for the who is counsel for the plaintiffs in the Thompson class action, and representative plaintiff Bernadette Becci, who will be speaking shortly. 5 years ago, we launched the largest employment-related discrimination case in Canadian history, spanning 99 federal departments and agencies and covering the period from 1970 to present. The case challenges a deeply rooted pattern named black employee exclusion, the entrenched practice of denying black workers hiring and promotion opportunities based on race in the federal public service. Since we filed this class action, the evidence of this exclusion has only intensified. In 2023, a Senate committee report found that the Canadian Human Rights Commission, the very institution meant to protect Canadians from discrimination, was itself discriminating against its own black employees and the public it serves. In 2024, an internal government document revealed widespread and shocking anti-black discrimination at the Privy Council office, the highest office in the federal public service. And just last fall, during the certification hearing for the class action, a government-funded report exposed a hostile and abusive environment for black executives, where some were pushed to the point of suicidal ideation. That report was not even considered by the court in its ruling. On March 13, 2025, the federal court issued its decision. While it dismissed our certification record for this class action to advance, it acknowledged the truth that black workers have known for generations. To quote Madam Justice Gagné, the court does acknowledge the profoundly sad ongoing history of discrimination suffered by black Canadians, just as it recognizes the fact that each one of the representative plaintiffs have faced challenges not faced by their non-visible minority colleagues in the federal public service. I will now invite Hugh Scher, counsel for the plaintiffs, to speak on our appeal position.
Thank you, Nicholas. It's curious that the court would recognize, as Nicholas has just noted, the acknowledgement of anti-black racism, discrimination against black workers, and the challenges that they have faced relative to others in terms of hiring and promotion in a way that has created disparity and underrepresentation greater than other groups. And yet, despite that acknowledgement by the court, by the government, nevertheless, the court turned a blind eye to relevant reports, relevant evidence, expert evidence about this underrepresentation, about this disparity, about the systems that have failed black workers for generations, be it the Human Rights Commission process, or the Labor Board process, or internal labor relations processes. Indeed, the court rejected the consideration of expert evidence from the former Chief Commissioner of the Ontario Human Rights Commission, who himself has constructed and administered human rights related commissions and boards across this country for decades. The end result is obviously junk in, junk out. You don't take into account the relevant and material evidence that was presented. You can't come up with a decision that is reflective of the true reality and the true experience as reflected by that evidence for Black people. So what do? We call on the Court of Appeal as we move forward in this next step to challenge, number one, the refusal to certify this class action. As Nicholas says, this is the largest class action of its kind in Canadian history. It names 100 different departments of the federal government and looks at the impact across the federal public service in terms of disparity, exclusion, and underrepresentation in a way that no other action ever has. And it seeks to do so in a way that will recognize the widespread practice and try to rectify it in one court matter. The court, by denying this certification and by denying the jurisdiction of the court itself to address the matter, has effectively told Black Canadians that they need to go thousands at a time before individual labor boards and human rights commissions and other bodies that have to this point for generations failed them, and nevertheless attempt to seek justice from them in the face of expert evidence that says that these bodies are not capable, do not have the capacity, the resources, or the expertise to assess and to indeed adjudicate the nature of a systemic discrimination claim, discrimination on a system-wide basis, and its impact on Black Canadians and Black public service workers in terms of disparities in hiring and promotion. So the court has effectively sent individuals on their own from board to board, from commission to commission, not acknowledging in many respects that these boards and commissions lack both the expertise, the capacity, and the jurisdiction even to deal with the problem. There are two bodies that have the jurisdiction to deal with this problem. One of them is the court, who can address a system-wide Charter of Rights violation, who can look at the visible minority category of the Employment Equity Act and can see that it has adversely impacted Black workers relative to others in a way that has perpetuated rather than assisted in the inclusion and representation of Black workers across the federal public service. The other body is Parliament. Parliament has it within its authority to settle this action, to work with Black Canadians and Black workers in order to implement system-wide changes that will seek to eradicate the practice of Black employee exclusion that Nicholas has alluded to, that reflects the widespread exclusion of Black workers, particularly from the highest levels of the federal public service compared to others, and the ghettoization of Black workers at greater levels than others at the lowest levels of the public service. So we call on the courts and we call on Parliament to do their task of reviewing and addressing this system-wide problem in a way that ensures fairness, merit, and equality for Black workers across the federal public. They want to serve. They ask only to be able to serve fairly and equally. And to this point, that's been denied. We will be calling on the courts above and on Parliament to make sure that this is not ignored further and that these issues are not denied, and indeed that they are acted on in a way that ensures fairness and equality for Black workers across Canada. Thank you.
Good morning. Bonjour. I will speak on the impact this decision has had on the workers. I've been asked to read the following statement on behalf of a Black executive in Canada's federal public service, who, out of fear of reprisal, cannot speak publicly. So these are their words. I'm a Black executive in the federal public service. I have spent years navigating a system that has tried to silence, deny, and erase me. I followed the rules. I filed a grievance after facing racism. My union turned me away. When it was finally heard, it was dismissed without care or consequence. Still, I kept going, believing things would get better at the executive level. It did not. It got worse. At the top, racism is more sophisticated. Coded feedback, denied opportunities, closed doors decisions. And the truth is, if you use the complaints process, your career is dead. The retaliation is real. The system protects itself. Dr. Rachel Zeller's report confirmed what many of us live daily. Anti-Black discrimination is rampant amongst executives. La personne continue. Je ne suis pas seule. Nous sommes nombreux. Cadres noirs et fonctionnaires réduits au silence, isolés, sans soutien et invisibles. Le recours collectif des personnes noires était notre dernier espoir. Notre seul chemin vers un véritable changement systémique. Nous avons attendu cette décision, impuissants, le souffle suspendu. Et lorsqu'elle est tombée, elle m'a brisé, ainsi que tant d'autres. Encore une fois, on nous dit de faire confiance à un système qui ne nous a jamais protégés. Un système construit pour nous exclure et qui continue de le faire. Nous ne demandons pas un traitement de faveur, nous demandons la justice. Une justice qui reconnaît les torts et met fin au cycle du silence et des représailles. Aujourd'hui, je reste dans l'ombre. Non pas parce que je le veux, mais parce que dire la vérité dans ce système pourrait tout me coûter. Avec cette décision judiciaire, même le peu d'espoir qu'il nous restait s'efface. C'est comme si nous ne comptions pas, comme si notre douleur ne valait rien, comme si nos voix ne suffiraient jamais. I wish I could end this with hope, but today all I feel is heartbreak. Even in this heartbreak, I know I'm not alone. And maybe, just maybe, that's where our strength still lives. J'aimerais pouvoir conclure avec l'espoir, mais aujourd'hui, je ne ressens que de la tristesse. Et pourtant, dans cette tristesse, je sais que je ne suis pas seule. Et peut-être, juste peut-être, que c'est là que réside encore notre force. Merci. Thank you.
Thank you very much, Bernadette and Mr. Scher, for those remarks. So as you know, we are in election season. Canada's general election is on April 28. So today, we call on all political parties, the Liberals, Conservatives, New Democrats, the Bloc Québécois, Greens, and others, to answer the question, where do you stand on justice for Black workers? Will the next Prime Minister continue spending taxpayers' dollars to fight Black workers in court? Or finally settle this case and deliver the justice that the government has already promised? We call on the next government of Canada, regardless of the party, to take 4 concrete steps. To implement the long overdue amendments to the Employment Equity Act, including the formal recognition of Black workers as an employment equity group, to finalize and implement the National Black Mental Health Program to address and to treat with the trauma that systemic discrimination has caused Black workers in the federal public service, to establish an independent Black Equity Commissioner to oversee accountability across departments and agencies, and finally, to settle this legal action and provide long overdue compensation and structural change to the thousands of Black workers harmed by exclusion and systemic denial. Black workers are the largest racialized group in the federal workforce, yet they remain overrepresented in entry-level positions and underrepresented in leadership, and disproportionately stuck in temporary and precarious roles. Some retire after decades of service without ever receiving a single promotion, even after training the very people who became their managers. So this is not a question of qualification. These are highly educated, bilingual, and overqualified professionals who have been systematically held back by a system that continues to fail them. We have waited long enough. So we're not asking for sympathy, but we're demanding justice. So to the next government of Canada, the time for symbolic gestures is over. The time for legislative action and systemic change is now. Thank you very much.
Yeah, could you speak a little bit more about the glaring holes that the appeal finds in the initial decision, particularly around the case law, and how maybe this initial decision was really focusing on the particular and individual rather than that systemic approach that the class action is fighting for?
I would note from the outset that the court fails to recognize that staffing matters within the public service are not matters that can be subject to grievances. Staffing matters by statute and by law are expressly excluded from the grievance process. They're not even the subject of collective bargaining. While grievances are related to the terms and conditions of employment, staffing matters are dealing with questions of defining merit, defining the categories, and defining the duties of particular positions and the processes that will be followed in terms of following different selection processes for hiring and promotion. The court, frankly, disregards what the Labor Board itself has found to be a bright line between the two specters of labor relations practices, which are clearly subject to grievances, that's what the grievance process is for, and staffing matters, including hiring and promotion appointments, that are the subject of the staffing regime and the staffing rules, and that have been impacted by this Black employee exclusion in terms of the definitions of merit, in terms of the choices of selection processes, and in terms of the manner by which the processes are approached. And by virtue of that, the court fails whatsoever to recognize the broad-based systemic impact and practice. The objective data is clear. Black workers in the federal public service, according to the government's own report, experienced a minus 4.8% promotion rate differential relative to other visible minority groups. They experienced a minus 7.6% promotion rate differential relative to other groups within the science and technology area. They experienced differing aspects of exclusion and demarcation. They fall off at greater rates in the hiring process than other groups at the interview stages or at the testing stages. And there's no explanation as to why, and no curiosity to both identify the systemic barriers and to redress them. But they're there. The reports of the government themselves acknowledge that. And yet the court viewed this as being the court made a statement, which is, when you bite off too much, more than you can chew, you end up with very little. You know what, with all due respect to the court, this isn't about euphemisms. If you're looking at a systemic practice, you're looking at a practice that applies across the entire system. This same practice applies across ministries, across departments, according to the government's own data as best we can determine it. And so the notion that we have to carve up the government into different departments and go department by department and individual by individual in order to address what is effectively a systemic class-wide problem, something that the clerk of the Privy Council acknowledged as a systemic class-wide problem in the 2021 call to action, which expressly called on managers and hiring deputy heads to hire and to promote black workers who had the merit to do so. The government itself has acknowledged the problem. The factual basis for the problem is reflected by the 2021 call to action itself, which reflects the acknowledgement of generations of underrepresentation and disparities experienced by blacks in terms of hiring and promotion. And yet the court is suggesting that individuals should be resorting to these individual mechanisms, which frankly lack the jurisdiction as a matter of law. That's what the appeal will be looking to address, as well as the broader issue about how the systemic practice needs to be looked at as part of a system. You can't just look at it's like cutting off your fingers and your toes and doing a scan of the brain and when you're looking at sort of the whole body perspective, you can't look at the whole body by cutting off key elements, key organs, key limbs. You need to look at the whole body. And that's what the government's failing to allow us to do here. Thank you.
Just to follow up, so you mentioned the Employment Equity Act. Could you speak a little bit about the kind of failures of the government to not pass those amendments by this next election and what really needs to change going into the next government?
The Employment Equity Act establishes several categories of employment equity groups: Aboriginal people, people with disabilities, and women, and then lumps in all racialized groups as part of a visible minority category. The problem with that is that the challenge for different visible minority groups, including Black Canadians, are rooted in their specific history, experience, and the barriers that they uniquely face. Something that Justice Rosie Abella recognized when reviewing the first Employment Equity Acts being put in place to begin with. Something which the Employment Equity Task Force that the government called upon to review acknowledges to be a serious and a real problem in terms of failing to identify the barriers, failing to recognize the specific underrepresentation and disparities experienced by black workers relative to other visible minorities. And that's why the Employment Equity Task Force has itself recommended the creation of two new categories, one of which is a category for black workers exclusively. The other one is a category to address barriers and to establish a specific category for LGBT workers, acknowledging that these particular groups have been significantly and adversely impacted relative to others. And in that regard, legislative action to implement a regime that reflects their history, their experience, and that acknowledges their unique barriers and addresses them by doing a comparison of the numbers and the proportionality of people within the service and within the population to ensure their representation is essential. And that's what the Employment Equity Task Force called for. That's what our action seeks to do. We challenge the visible minority category as being under-inclusive and unconstitutional for this very reason that Justice Abella, formerly of the Supreme Court, herself acknowledged 40 years ago as being a problem. And the government itself has acknowledged it. The last government said they were going to implement it. They didn't. So here we are, still asking the courts, still asking the next government to take action to address this, which will hopefully, create some positive impact in terms of identifying barriers, eliminating disparity, and reducing underrepresentation across the federal public service by obligating ministries and deputy heads to take steps and to be accountable for failing to do so. The challenge is, can the system be made to work? To date, it has not worked to serve black Canadians, and the objective data just makes that clear. Thank you.
I have no questions online, so if you have.
Can I ask one more? Is that okay? Just kind of one last follow-up. I'm just to get a sense of where the Secretariat at. How do you feel in terms of confidence that things will change and how this class action will move, not just settlement, but real systemic change in the public service?
Well, so far we have seen quite a bit of movement in the federal public service since we shone the light on systemic discrimination in the public service. And the issue before the courts, I think we're cautiously hopeful that the wheels of justice, it turns, but it turns very slowly. And this far, and while we respect the court's decision, it is our position that it has only reinforced systemic discrimination, utilizing the laws and the procedures and all the technicalities, while clearly acknowledging that a large group of people are being harmed, and not accepting that, applying its discretion to remedy that, particularly with all of these reports. So we're cautiously hopeful that the higher courts will take the bold and courageous step to create new law that, yes, the grievance process, and we recognize these systems for the labor framework, but when these systems are so entrenched with discrimination, when the decision makers, when the bodies, the mechanisms created by Parliament has so much racism in it, that the court would accept jurisdiction in cases that's wide, that's broad, that's across the board. We have the Canadian Human Rights Commission, the Privy Council Office, all of these bodies. There's so much racism inherently in them, and I mean, how do you get justice from these systems? How does anyone try to access these systems as an effective remedy to redressing? It's just insane. So at some point, we intend to fight as far as we can go, and what we're also hoping for is a political solution. We've seen in the 2S LGBTQ purge case, that case didn't even go to trial, or the government recognized the harm caused to that community and settled that legal action. Now, these same remedies that the court has said is available to workers for redress were there for these workers. They were there for the mechanisms were available for the RCMP and armed forces harassment complaints. These mechanisms were there. The government recognized the harm and created a political solution and resolved those actions. So why is it any different for black workers that you continue to say over and over, we're harming these workers, there is harm, we're working to address it, but you refuse to compensate these workers for the harm. You refuse to create institutional change. Since 2021, the government commissioned the Adele Blackett Task Force. Since December 11th, 2023, the Minister of Labor committed to recognizing black people in the Employment Equity Act, which we believe would be significant in removing black people from the racialized category where they're constantly being excluded, where the practice of black employee exclusion thrives. And the Blackett Task Force did years of consultation. So when the minister announced that they were going to take these steps to recognize it, we saw hope. And they went back to do more consultation and more consultation and more consultation. After the Blackett Task Force interviewed and consulted over 300 bodies across the country, spending years and taxpayers' money, and more consultation. And it's very, very frustrating for workers to see this. So we are really calling on the next government, whether it's the Mark Carney or Per Poilievre government, to address the legislative gap, because that leads to the policy changes in the federal public service, And as long as black workers continue to be a part of any racialized group, the bias and the systemic issues will continue. So there must be an employment equity group for black people which would recognize the distinct harm that black people have faced.
Just one last question. You mentioned how you're willing to fight. Are you, is this a place that you could see fighting all the way to the Supreme Court, or are you prepared to do that?
It's certainly a case that is worth fighting. We're not just talking about black workers today. This is not just about black workers. It's about all underrepresented workers, because we've seen in civil rights that when rights are won for black workers, it's all workers. And right now we're seeing how this fight is lifting up all workers in the public service, because as the glass ceiling is removed from the bottom and black workers move up, those who've already been the beneficiary of employment equity are even moving further up into leadership roles that have been largely exclusive to white employees in the federal government. So this fight is for fairness in the federal public service, and not just the federal public service, but beyond. So it's a fight that we're committed to fighting all the way as far as we can get, if that's the Supreme Court, because this is what it means to be Canadian. This is what Canada has promised the world and has purported to be a beacon of human rights and justice, and where everyone is welcome and included, and diversity is our strength. So we are fighting to hold Canada to that account. Thank you.
And this concludes the press conference. Thank you.
All right. Thank you.